Case on our docket this afternoon is 12-70035, Mendoza versus Lumpkin. Mr. Zarrow.
Were any of you the advocates 8 years ago when we last had argument?
No, Your Honor. The lawyers.
I was guessing not.
As you instructed. May it please the court. Jason Zarrow on behalf of petitioner Mrs. Mendoza. I'd like to reserve 5 minutes for rebuttal. I'd like to start, if I may, with the merits and then turn to the procedure. To decide Mendoza's fate, the jury had to answer 2 questions. Was there a reasonable probability that he would continue to commit criminal acts of violence? And were there sufficient mitigating circumstances to warrant a sentence of life rather than death? Mendoza's life came down to these 2 questions, and all he needed was a single vote from a single juror on either one. But Mendoza's lawyers elicited testimony from their own expert, answering both questions decisively against him. On mitigation, Dr. Vegan told the jury that the mitigating factors typically present in death penalty cases were missing, and he offered the jury nothing in the alternative. In other words, he conceded the mitigation special issue.
Well, counsel, I think that is where the battle obviously is fought. You say they're offered nothing. I think all 3 of us have looked at the transcript pretty closely. He didn't offer them nothing exactly, it seems to me. There are 6 opinions he stated, enumerated by counsel. And he went through them and he basically was saying those were missing, but there were other parts of his life, teenage years and others, his father going through depression, losing a job, badly injured, I guess, at the workplace or something. It does seem to me he constructed a story that, I won't say constructed as if he fabricated it, presented a story based on his psychological examination that, you tell me why it doesn't make some sense based on, as far as we know, the available psychological evidence.
Your Honor, so 2 points in response. The first is, I don't think he offered that story as an explanation for why Mendoza committed murder. As I read the 6 opinions, they're mostly unrelated. They weren't connected in any way that told the jury, here is the explanation for why Mendoza did this. They were just a series of opinions. Again, as I said, unrelated. The second point is, as I understand it, what respondent has said is that Mendoza was immature. His immaturity led him to be susceptible to outside influences, and that somehow led or explained why he committed murder. I don't think that theory makes any sense. I mean, plenty of people are immature. They don't commit murder. If the theory was that Mendoza was especially susceptible to outside influences, that theory was inherently double-edged, as this court recognized in the companion case to this case, actually, Spear versus Lumpkin, where the court said that there was no prejudice because the theory that someone was especially susceptible to outside influences, it would, for example, in that case, commit murder to please others, would cause a jury to conclude that the person was going to be more dangerous in prison. So that sort of explanation, I think, would be objectively unreasonable because it would cut against Mendoza.
Wait, just 1 second. You know, when this whole double-edged theory came up, it was in Supreme Court opinions. I'm not saying it originated there, but they said, nevertheless, that counsel would be shirking their duty if they didn't put all of this in front of the jury, didn't they? I mean, they didn't say you should never introduce double-edged.
No, they didn't say that you should never introduce double-edged evidence, but I don't think in this case that's an explanation for what counsel was actually doing. And I think what I'm trying to suggest here is that one of the reasons they probably didn't do that and should not have done that is because it would have been double-edged, because it would have led the jury to find against Mr. Mendoza on the future dangerousness issue. And the reason being, there are more dangerous people in prison than Mendoza's friends who are outside prison. And if Mendoza was especially susceptible to outside influences, he would then, the logic would go, be more dangerous in prison. But when I look at the record, I at least don't see any explanation offered by Dr. Vegan for why Mendoza committed murder. And then on top of that, he said the traditional factors of mitigation were absent. Just to circle back, I think the theory here is there was a sort of a good with the bad, right? We're going to give you the bad, the traditional factors aren't absent, and then offer something good in exchange. But what is missing from this record is something good. On respondent's theory, moreover, and in response to your question, Judge Southwick, it doesn't explain like huge swaths of the testimony for Dr. Vegan. Even if that was the theory they were offering, it doesn't explain why, for example, Dr. Vegan started out his first opinion elicited on direct examination with the fact that Mendoza didn't have a sense of self. He was, it doesn't explain why Vegan said that his remorse was only superficial. Dr. Vegan defined a sense of self.
But he said that, he followed that. He said more. He said himself, but he could find himself at the prospect, which he was in prison. The doctor picked up when the jury had just convicted this man of capital murder. And I thought when I read that testimony, he moved forward from that point. The jury had just convicted him of a terrible crime, horrendous facts. And at that point, then he responded at that level.
Your Honor, you're correct. His sixth opinion was that he could someday develop a sense of self, which Dr. Vegan defined to be an internal compass and something, as I read the testimony, equivalent to empathy. He said the ability to connect with others and understand how they're feeling. That's, I think, the common definition of empathy. But the problem with that testimony in particular, that last opinion, is that essentially what Vegan was saying is right now there is nothing redeemable about Mendoza. At some point in the future, there might be. But the jury's task was to determine whether at this point there
What should he have done?
What he should have said is outlined, Your Honor, at pages 8 through 10 of our opening brief, the mitigation story that we think is present on the factual record, and that respondent in this litigation has multiple times said is compelling. So the story that they should have told is this. Mendoza suffered from severe psychiatric illness and needed psychiatric help. He had severe depression, he was suicidal, he was, instead of getting the psychiatric help that he really needed, he was self-medicating with drugs and alcohol. On top of that, there were here traditional mitigating factors that Vegan said were absent, including possible sexual abuse by an older male cousin. And on top of that, his sexuality may have been repressed by his strict Catholic family, supportive as they were. But in prison, Mendoza could have gotten the psychiatric help that he needed.
Your counsel, over the years, we see these cases of this came back in 75 and working forward. And with very few exceptions, you look at these defendants, and they had horrendous childhoods, abuse, and I mean terrible childhood, and that always jumped out at you. And here you don't have that, and so that's the environment in which this expert, Dr. Baggett, was to testify. He was dealing with an unusual case, and coupled with some very, very bad facts.
Your Honor, it's an unusual case, I think, in both respects. It's not like, for example, Rompia, where there was, lots of abuse of the person in their youth, but also in many of these cases, you don't have an expert saying the traditional facts in mitigation are absent. So I think sort of on both sides of the ledger, it's an unusual case. And I really want to stress the point that it seems highly, highly unlikely to me, if not impossible, that a juror who hears from an expert who's done 100+ capital cases, that the facts I traditionally see in capital cases in mitigation are absent, I don't think a jury after that could find mitigation, even if there was some alternative mitigation theory present on the record, unless the expert made a pretty strong case that although these traditional factors are missing, there are these very powerful, in this case, non-traditional factors that are present on this record, and that's not what Vegan offered. That's, I think, the key of.
You keep saying about traditional factors. We see these in death penalty cases. I mean, the mitigating factors that you talk about have been presented, and juries have chosen the death penalty anyway. I mean, there doesn't seem to be any clear mitigation path that gets juries to say no death sentence for you.
Right, and I think that's our point on prejudice, which is a jury could accept it, a jury could reject it. All we need to show is a reasonable probability.
But we know that juries routinely reject it. Is my point.
They do, and other times they don't. And the point in this case is that, but for Vegan's testimony, there would have been a possibility on the, I think, based on the factual narrative that I said, derived just from the record in this case that was presented to the jury, one juror could have dissented. It's true, of course, that in some cases juries hear terrible, terrible evidence and in mitigation, and they still nevertheless impose the death penalty. But
Counsel, one thing also that jumps out at me about what this counsel did is the question of the ability of the witness to relate to the jury. A lot of people don't accent that very much, but those who have been around the courtrooms and jury trials and will tell you in a hurry that that's one of the large considerations. And with experts and whatever, you get someone lecturing to the jury or coming at a different evidence, they don't have the same kind of credibility. So as I read what the counsel was trying to do was, went with this witness, there's a lot of things they had to give away because they didn't have much, but if they could establish rapport with the jury, that then the testimony that in fact in prison, he will regain himself. So I come back to the question of the choice by counsel of this particular expert. And what I don't see giving much credence in your arguments to is the question of how that witness relates to the jury. Unless that witness relates to the jury in a positive way, you're going to lose anyway.
Your Honor, I think in some sense, I agree with everything you said about the power of experts connecting with the jury. Yeah. That's part of our prejudice case, which is this is coming from an expert from the defense. He's got the court's imprimatur in the sense that he's an expert. He's speaking for the defendant. Everything that comes out of his mouth is an admission. But I don't think he needed to build credibility with the jury by saying the traditional factors in mitigation were absent, when there are traditional mitigation factors in this case, including mental health issues, possible sexual abuse, and repressed sexuality. And even so, if he was going to do that to gain credibility with the jury, he needed to offer them something meaningful in the alternative, and he didn't do that.
Well, Counsel, you say there's nothing meaningful. Obviously, you're doing the best you can, just as I guess Dr. Vegan was at the time, and you may be doing a far better job than Dr. Vegan was. But nonetheless, it does seem to me it's a plausible story that he laid out. And I won't go through all 6 opinions. You know them better than I can, and you'll correct me when I mess up. But one of them is that the state of Texas has a pretty good, I must say I found this an unusual approach, but the state of Texas has a far better system for dealing with people like Mendoza than Louisiana. His experience was more in Louisiana. That he felt Mendoza would get some help in prison, that some of what was missing in his life from his lost father, lost from his life father. He really did emphasize, seems to me, some of the traditional mitigation factors. I will also say on traditional mitigation factors, these jurors didn't know anything about what those were, and other than to the extent others told them. So I don't know, telling the jury I'm not going to give you the usual factors, I'm giving you something different, that may actually have been better. All I'm saying is there was a story here. It's somewhat held together. It didn't convince. You can say that about an awful lot of mitigation cases that have been presented. And you have to convince, obviously, us at this point that this showed such ineffective assistance of counsel as to entitle you to relief. And I think it shows, and part of that would have to be that this story just doesn't at all uphold the obligation of the attorney. And you're telling us that, but I think you're getting some responses from us as to we haven't necessarily sold us yet.
Yes, you're right.
I don't want to speak for my colleagues. You haven't necessarily sold me yet.
All right, and I will use this as an opportunity to turn a little bit to the future dangerousness special issue. I'll just say one last piece on mitigation. Dr. Vegan, and through his own...
Is that actually how you pronounce his name? Does anybody know?
That's my understanding. I don't know.
Or maybe Vigan, but anyway.
The story didn't cohere, and to the extent it cohered, it painted a double-edged picture that was going to lead the jury to find against Mendoza on future dangerousness for the reason I said. He also, just as a factual point, there was a definition of traditional mitigation factors that Dr. Vegan offered through counsel and on cross. Like, these are the traditional factors you see. But I'll take this opportunity to turn to the future dangerousness issue. So as Your Honor identified, the story that counsel wanted to present to the jury was that Mendoza would not be a future danger in prison. That was their theory. That was their focus. When the prosecution rested its case, it gave Mendoza's defense a gift. The prosecution hadn't offered any evidence of Mendoza's dangerousness in jail. So at that point in time, Mendoza's counsel could have made the exact same argument they were making, but held the prosecution to its burden of proof. So to do so, all they had to do was not offer from Vegan Mendoza's criminal violence in jail. that evidence would have been excluded, the rebuttal wouldn't have come in, and then counsel could have argued.
Why would it have been excluded? Why couldn't the state have put on affirmative evidence on future dangerousness totally separate from his expert about his behavior in jail? That's all it's done.
Yes, Your Honor, they could have done it in their case in chief, but they didn't. And then typically rebuttal is confined to the scope to rebutting rebutting the other side's case. So if Mendoza's case didn't offer evidence of his violence in jail, any rebuttal put on by the state would be on that score would have been beyond the scope. Then what they could have done, and I don't think this is like a multi-step process, all they had to do was not offer evidence of Mendoza's violence in jail, and then they could have simply argued to the jury, look, the prosecution bears the burden beyond a reasonable doubt of proving his violence. Our theory to you is he's not going to be violent when he gets help in prison. The prosecution offered no evidence of violence in prison. Presumably, if they had such evidence, they would have offered it. The prosecution hasn't carried the burden of proof on
They didn't need foil to offer it as rebuttal evidence. They could have offered it at any time they wanted to.
I don't think the prosecution could have offered the evidence at any time they wanted to, because the typical rules of litigation is that a rebuttal case is limited to rebutting what the other side does.
Yes, it's sequenced that way, but the fact is that the person is, once the person's in prison, the only question is prison life, the threat to others.
Right, Your Honor, which is why I think it was somewhat perplexing for the prosecution not to offer evidence of Mendoza's jail conduct in its case in chief. But once the prosecution did that, defense counsel, I think, could have stopped that evidence from coming in this trial.
Do you have a case that says that?
Your Honor, I don't have it with me, but we certainly can provide that or look for that in a letter. The state here has not offered an argument that they could have offered the evidence nonetheless. I think the point here is either conceded or not disputed that the evidence wasn't coming in unless Mendoza's lawyers elicited it from Vegan against him.
Well, what you have.
You critiqued him for conceding that he was a very dangerous person, and but he did that after the jury had convicted him.
Correct.
So to maintain any credibility of the jury at all, he had to concede that. Given the crime they just found him guilty of as capital murder, he couldn't have softened that. So.
Your Honor, I want to just be clear that there are sort of two different pieces of the argument working here. One is with respect to Dr. Vegan's statement that he certainly agreed with the jury that Mendoza was dangerous in a free society. The other piece of the argument, which is independent, is the argument that counsel should not have affirmatively injected Mendoza's prison or jail record into the case. With respect to the piece that you're identifying, I think that most clearly to me shows that defense counsel was operating under a mistake of law. And the mistake of law here is that future dangerousness outside prison is relevant under Texas's capital scheme. And once Vegan had said that on cross-examination, a reasonable lawyer who realized that Mendoza's dangerousness outside prison was relevant to the jury would have at least done something to explain that although Vegan, on cross or in closing, especially after the prosecution emphasized this in rebuttal by saying this is our, the reason that you should answer special issue number 1 for us, should have said something to the effect of, it is true that he committed murder, we're not quarreling with your verdict, but, notwithstanding that, there's still a possibility that you can find for Mendoza or against the state on the future dangerousness special issue. And this court's cases, in fact, have recognized that even in cases with brutal murders, a jury can still find against the state on the future dangerousness.
Why was Lydia Brandt ineffective for making these arguments?
For making these arguments? Well, Your Honor, I think the claims are actually quite different, and the state explained why a little bit in its brief in the relation back argument, but the claims are legally different. So
Lydia Brandt was federal habeas counsel.
Correct.
And she should have argued that why was she as state counsel ineffective for making the arguments that you're now making?
Right. So I think the primary argument is that habeas counsel under the ABA guidelines and under the Texas guidelines and under the Supreme Court's decision in Martinez has an obligation to preserve substantial claims. This court has already found that the claim is substantial. There is no strategic justification, especially in a pre-Martinez universe, which is where Lydia Brandt was operating, for defaulting a substantial claim, because what that means in practice is that almost in all circumstances, no court ever will have a chance to consider the claim on the merits. So a habeas lawyer's number one responsibility in these circumstances, and again, this is recognized in the applicable guidelines and in Martinez itself, is to preserve substantial claims. Can't be effective if you're not preserving a substantial claim, and in this case, we think the claim is meritorious, which even more so shows the ineffectiveness. But preserving other claims in the neighborhood still doesn't offer a strategic reason for defaulting a claim that's substantial. And I think, I don't want to stress this point too much, but I think this court recognized in its grant of COA that the claim is substantial and that it has at least some merit, and there is no plausible strategic justification for defaulting a claim that has some merit. Because again, what that means is that no court is ever going to hear the claim. On top of that, I think the theory from respondent is that Brandt engaged in strategic winnowing from her petition, right? She omitted some claims on the theory that the stronger claims, I'm putting those in quotes here, would be more likely to be accepted by the Texas habeas court. But Ms. Brandt told this court in argument that she didn't do that she asserted every claim she knew how to do. And Judge Higginbotham, I think you made the same observation. And if the theory is that she was omitting claims because they were so factually related, that theory doesn't explain her conduct, because she asserted claims that were far more factually related than this claim is to the claims that she did assert in her state habeas petition. And I would direct the court to claims 4 and 5, which she incorporated into one another. They were basically the same claim. So the theory that she was omitting claims because they were factually related, that's what I understand the state to be saying, just doesn't make sense on this record. If I may, with my remaining time, I would, unless the court has other questions on the merits, just briefly like to touch on the issue of jurisdiction. So I think, as we set out in our brief, there's 4 different paths for this court to go to find that there is subject matter jurisdiction and that the second or successive bar doesn't apply. The 2 easiest are that the court's prior mandate, in this case, also in the companion case of Spear, also in the Spear panel's decision.
The Spear panel decision punted on these jurisdictional matters. It was the same panel, same 3 panel members here remanded in that case for similar reasons. And the same arguments were made on the return by the state that have been made here. And that panel just didn't resolve them, right?
Well, Your Honor, I don't think you can punt on subject matter
Well,
jurisdiction.
but it did.
So I don't think the Spear panel in 2021 could punt on subject matter jurisdiction.
Which says a variety of arguments here we need not consider. And I think those were the arguments.
Your Honor, I could not pretend to know exactly what you were intending. All I can say is with the...
Well, I didn't write that opinion. I'm just saying that panel didn't deal with it.
The panel didn't deal with it, but it did implicitly, because there's no way not to deal with subject matter jurisdiction.
Oh, yes, there
and
is.
then reading, and then I understand the point, but so setting that aside, I'll just cut to the merits if you don't agree that the prior mandate resolved it under either the law of the case doctrine or the rule of orderliness. This court sent the case back to the district court with an order to appoint counsel and consider any new claims that were asserted. That is incompatible with the final judgment under Section 1291, because a Section 1291 final judgment is a judgment that terminates litigation on the merits. That's black letter law. Once the judgment was no longer final, it was possible for Mendoza to submit an amended petition. It should probably have been asserted as a Rule 15 motion to amend. And under accepted law, a Rule 15 motion to amend can be asserted on remand, provided that the claims are within the scope of the appellate remand, which is true in this case.
Let me ask you about our now Chief Judge's concurring opinion on the remand. She offered some reason why Martinez-Trevino might well open the door, even though it's not being done in the way subsequently. It's the original federal habeas counsel had already been appointed, and off she went and did not make this claim. So the state certainly has a basis for his arguments about this is not the way it usually works. Is there any case law that you've cited to us, I don't recall, from some other circuit that actually has explicitly said that you don't have the statute of limitations or the successive petition problem?
So Wood v. Milliard, that's a Supreme Court case, resolves the statute of limitations on waiver grounds. On the second or successive, I would point the court, it's not holding of those courts because they don't have the exact procedural posture here, but Santorelli, the Third Circuit opinion, sort of lays out how this works. And let me just be
Not
clear.
exactly on point.
It's not exactly on point, but it sort of, in explaining its reasoning, I think that applies here. The state also doesn't have anything that applies in this particular procedural
Other than the
posture.
statute.
Say that again?
Other than the statute, I would think.
Well, no, Your Honor, that's the point I want to get to. May I finish? It's going to be a
Well,
little
I'm
bit
not
longer.
presiding, but you can answer questions, is my understanding.
Thank you, Your Honor. So this is the way I think it works under Bannister and Gonzalez. Bannister and Gonzalez say you need to identify the federal rule of civil procedure that is operating. Once you do that, you ask the question, is the application of that procedural rule consistent with the federal habeas statute? In this case, the federal rule of civil procedure that's operating is Rule 15, and a specific provision of the federal habeas statute says that, this is section 2242, as we set out in our reply brief, says that Rule 15 operates in full. So unlike in Bannister or Gonzalez, you don't need to ask if it's consistent in this way or that with the habeas statute, because the habeas statute already tells you that Rule 15 is consistent. What 2242 says is that habeas petitions may be amended consistent with the rules of civil procedure, and the rules of civil procedure allow a post-remand amendment consistent with the appellate mandate, subject, of course, to the many doctrines that would bar amendment, like Rule 15 itself, like the statute of limitations, and many others that are set out in our reply brief and also in Santorelli. But the baseline point is that the federal habeas statute actually answers this question for you, 2242.
May it please the court, I'll just pick right up where counsel left off here. These claims are second or successive for a variety of reasons. We've discussed it at length in our brief. I think the important thing to focus on with regard to the second or successive issue is first, as Judge Southwick pointed out, the court has not resolved this issue, and the Spear holding, of course, did punt on it. There's no such thing as
But it couldn't punt.
There's no such thing as a drive-by jurisdictional holding, Your Honor, so.
With all fairness to that very able panel and the writing judge, didn't they effectively not resolve jurisdiction?
That's right, but the court rejected the claim on the merits. But Steele Co. says that there's no such thing as a drive-by jurisdictional holding. We can't just assume that the court issued a holding on jurisdiction. So that takes care of that rule of order.
Well, it wouldn't be precedential regardless. It would just be another case. I mean, it's an
Indeed.
unpublished opinion, right?
Indeed.
So we were looking at this without any guidance from presidential authority.
Yes, and this claim is second or successive because this court never actually vacated the judgment below.
Well, let's back up. I mean, because I have a hard time with this. We had Ms. Brandt, who had been state habeas counsel and now is federal habeas counsel. And then we have Martinez and Trevino come along. And she has a conflict of interest because if she was ineffective as state habeas counsel, she would have to call herself ineffective as state habeas counsel. And the Supreme Court is clear that even if there's not a constitutional right to habeas counsel, once you've got counsel, you're entitled to competent counsel. The statute contemplates competent habeas counsel. So we stopped the proceedings where they were and said, Mr. Mendoza is entitled to conflict-free counsel, to look at the record again, and if there are claims that state habeas counsel was ineffective for failing to raise, this is the time to raise it. Now, that doesn't mean we vacated. And so let's assume that new counsel found legitimate ineffective assistance of state habeas claims. What are we to do with that under Mendoza and, Martinez Trevino?
Well, Your Honor, the second or successive bar, of course, is a separate problem than the procedural default question.
Well, that
is an issue.
Martinez Trevino says we got to do something. I mean,
Well, Your Honor, the court held in Spear back in 2015 that Martinez Trevino did not require the appointment of additional counsel.
it didn't
Now-
require it, but we did.
Yes.
So
and-
let's assume we were to find that state habeas counsel was ineffective per Martinez and Lopez. What are we to do with that?
Well, Your Honor, the court should nevertheless deny relief if the court.
What do we do with that in the context of successive claims?
So if the claims are successive and can't be authorized under 2244, then they can't be brought at all regardless of their merits.
Where does Martinez Lopez fit in that paradigm? You're not answering that.
I'm sorry if I misunderstood the question, Your Honor. Martinez and Trevino deal with procedural default, which of course is a separate hurdle that a petitioner has to. I understood Your Honor's question to be going to what happens with a second successive petition.
Well, Martinez Trevino meant nothing. It's totally hollow. If you send it back and conflict-free counsel finds that state habeas counsel was ineffective for raising trial counsel ineffectiveness, and you say, but it can't ever matter because that's going to be successive.
Well, I wouldn't say that it can't ever matter.
All right, tell me when it does matter and when it doesn't and why.
So there are two scenarios that I can think of where it would make sense to have taken the belt and suspenders approach that this court took. One, it was possible that the new supplemental counsel wouldn't find any other claims. And then we would know we've done all we can for this petitioner as it comes to Martinez Trevino. There's nothing else there. The other scenario is that new supplemental counsel might have found IATC claims that can clear the second or successive bar. And in that case, if the claims were, for instance, actual innocence and a new factual predicate, or a claim based on a new rule of constitutional law, then the claim could be brought even in a successive posture.
That's not what Martinez Trevino said. It said the first time that you can bring a claim is on, effectively bring it is on state habeas review. So we're back at initial state habeas review. And you are prevented from bringing that claim the very first time you ever could. It's not successive because of ineffective state habeas counsel. You've got a problem.
Absolutely, but subsequent precedent has clarified that that holding is limited to cause and prejudice for overcoming procedural default. Those are judge-made doctrines not affected by EDPA. The second or successive bar is a statutory doctrine, just like 2254E2.
Well, let me ask you, is the distinction you're making, the difficulty here, we were in the transition period from pre-Martinez Trevino, post-Martinez Trevino. So if it wasn't Lydia Brandt as the initial counsel, which creates a successive petition bar, right? If the first federal habeas counsel had presented all of this, we would not have any of what we're now talking about. Correct. So the reason I was referring to our able chief's concurring opinion on the remand 30 years ago, whatever it was, 8 years ago, 2015, is that she laid all that out. And it does seem to me during that transition period, when there was no reason Lydia Brandt should not have been appointed federal habeas counsel, but then we learned, yes, there was. I don't know. It seems to me that what you are saying, and what the state of Texas is saying, I'm not trying to make it more bold by saying that, what you're saying is that during that transition period, when this happened, the inmate's just out of luck. There's no way to make it happen, even if entirely plausible, as far as you know, we may find these legitimate new complaints that should justify habeas relief. So just take that as a premise. You're saying there's nothing can be done about it because we were in that transition period. And I'm not sure there's any case that says that. And it does seem to me that this is a reasonable approach to deal with the reality of Mendoza's case.
So, Your Honor, a two-part response to that. In 2015, at the time that the panel made that decision, there were scenarios where there wouldn't have been a problem and the claim could have potentially been brought up to this court without running afoul of the second or successive requirements. That's just not what ended up happening. And of course, the panel didn't know that ahead of time. So our argument doesn't go to the propriety of the remand.
I don't think the panel was concerned about that. What we were concerned about was a legitimate claim that could have been brought by the first habeas counsel, now under Martinez Trevino.
Absolutely, but Your Honor, habeas petitioners have made that argument before, and the Supreme Court rejected it in Shin v. Ramirez.
No, it did not.
It has to do with a different statutory provision, but they rejected the idea that Martinez Trevino can be used, the sort of,
All it said, you can't have the evidentiary hearing. You only can look at the state record to decide if state habeas counsel was ineffective. That's all Shin said.
Well, Your Honor, as I read Shin, the court rejected the idea that if there is a statutory bar to some sort of federal
Well,
proceeding,
successive would have been a statutory bar to Martinez and Trevino, the way you're reading it.
I don't believe that's correct. In both of those cases, it was undisputedly an initial federal habeas
Well,
petition.
this was an initial federal habeas petition.
Well, we contend otherwise. Now,
Well, what if we disagree with you?
if the court disagrees with you, of course, the claims fail on their merits, and I'm happy to turn to that if that would be more helpful.
No, I want you to explain to me logically how we fit Martinez Trevino in with successive petitions where you've got conflicted counsel who's filed the first federal habeas petition. And then on appeal, we get Martinez Trevino. What are we supposed to, how does that fit in with the successive statute? So that you can get effective relief under Martinez Trevino if it's called for.
Your Honor, there may be some cases where the court can't reach those claims.
Why?
That's not the fault of the court or the equities. That's the fault of the statute. That the
Tell
court's
me
operating
how the
under.
statute reaches claims that, how the statute reaches a claim under those circumstances.
So instead of this case, let's say that there's an undisputed second or successive petition. All appeals are over, even under the Third Circuit's approach, Santorelli, that case is over, 5 years go by. Petitioner gets some new counsel and decides, I think there's a new claim. It should have been raised the first time. My habeas counsel was ineffective for failing to raise it. Everybody would agree that when he brings that, it's a second or successive petition. 2244 would apply to it, even though underlying his claim, he's got a Martinez Trevino argument. The 2244B would apply, and the court could not, or the first thing that would
Because
happen.
his federal counsel, his non-conflicted first federal counsel failed to raise it. You're out of luck. Here, we said, let's get a new first federal counsel.
Indeed, Your Honor. And our position, as we've explained in our brief, is that there's no reopening of the judgment here. And so this doesn't fall into the category of a continuation of the initial federal habeas petition, the way that a 59E motion does, for instance, in Bannister.
Well, the district court didn't know who federal habeas counsel, the state habeas court did not know who federal habeas counsel would be, right?
Of course not.
And then we didn't know there was a conflict until.
Indeed. And so no one can say that this court hasn't given the petitioner every opportunity to bring these claims. The court took a belt and suspenders approach in 2015, as the Spear opinion explains, and that gave him an opportunity to identify these claims and try to raise them. But the district court concluded that those claims fail on their merits. And
That's not successive, that's a different issue.
absolutely. I'm sorry, I didn't realize there was a question pending about the success.
So let's go on.
So turning to the
Before
merits here.
moving on with due respect, Chief, let me ask one more question about this. It seems to me you are putting this particular case, since it had left district court with a judgment, in the category of one predating Martinez Trevino that had gone through the whole system, including federal. And it was a conflict with federal counsel, Lydia Brandt even. She did not recognize any of her own ineffectiveness, and the 2254 was completely resolved. And then 5 years later, Martinez Trevino. That can't be brought as a new case because of successive petitions. And I don't know, and so you're saying these gap years come on one side of the Great Divide rather than on the other side. And I think that's for us to decide. I do think Ramirez is a problem because it does talk about statutory bars cannot be loosened by courts worried about, I don't want to use the inappropriate word like equity, but trying to provide justice in a particular situation. But I just find this very troubling that in this case, when it was not actually final on appeal, where we remanded without vacating yet, to allow the same district judge in the same proceeding revived by our remand, why that wouldn't be different, and why wouldn't still be on the first petition. Is there not a way for us to perhaps now vacate I don't know what year the district court judgment was, because it was a limited remand, wasn't it? We would maintain jurisdiction, came back to the same panel. So we still had the original case in front of us. What
Yes.
happens if were we to vacate that first decision? Would that make it non-successive to add this?
Now, I would agree that if in 2015, the court vacated the district court judgment and sent it back and then all of the other requirements were met, there wouldn't be a second or successiveness problem.
But don't we still have that possibility in front of us? Why wouldn't we? Because we have not ruled and we maintain jurisdiction, so it's only a limited remand. So a complete remand now could do that.
I suppose, Your Honor, I certainly would urge the court not to do that, given that this case.
Well, I'm just talking about on the successive petition bar. Would that take care of the successive petition bar in your view?
Now, I don't think that the court could post hoc vacate and
Why would
send
it be
it back
post hoc?
now, given
Why
that-
is that post hoc?
because the district court has already rendered its judgment, the 28 days have passed.
But on a limited remand with the whole case still in front of us without our making a decision on any of it.
Well, Your Honor, if what the court had done, and perhaps that this is what the court had done, we didn't read the 2015 remand as vacating the judgment, and it never
It didn't
said that it was.
vacate.
But if it did, we would agree that we would just be talking about whether the amendment is proper and all of the other requirements. And our brief has explained why we
Well, there
think.
was no reason to vacate the judgment because we didn't know if there were other claims out there. We halted the procedure to see if there were other claims. Now we're back. This is still the original bill from the district court's judgment. And we also know from the U.S. Supreme Court, if while it's on appeal in our court, the law changes, the new law applies, not the law that was in effect when the appeal started. So
If this is still the original appeal.
it is.
Then it's not second or successive.
Thank you.
No dispute about that. Now, we disagree that it's still the original appeal, but if it is,
Our mandate.
Let's take that and once you move on.
Yeah.
I'll
let's take that.
absolutely give to you that the second or successive problem is resolved. As to the merits, however,
Welcome to the merits.
the district court already denied relief and it did so correctly. I'll just touch briefly on the second claim, which is the subject of the motion requesting a Ryan stay. And I'll note that the petition, there are only two scenarios in which that claim exists. One is procedurally defaulted. That's what the petitioner said in 2016 and in the COA stage. And if that's the case, then I don't understand the petitioner to dispute that it would be futile to remand for a Ryan stay. Now, his new theory is that it wasn't actually procedurally defaulted and he could pursue it in a successive state habeas claim. But if that's the case, then he agrees it's not properly before the federal courts. That's recognized in the reply brief in footnote 13, maybe 14. So either way, the court needs to simply affirm that judgment. And then the question of whether he brings this in a successive state habeas petition is a question for another day.
Is there any restriction on him bringing this claim now in the Texas Court of Criminal Appeals?
Not that I'm aware of, and
So
certainly
we don't really need to do anything on that, it would seem.
the court should affirm the district court's judgment, and nothing that this court does prevents him from making a run at it in the state court.
He obviously wants the backup of, I would think, of this court still having the issue in front of us if we went through those steps. But it does seem to me that on, I forget the 11701, whatever the number is on the Texas code, this could be brought in state court without any propulsion from this court.
Well, they won't accept anything while it's pending here. That's pretty clear.
Okay.
Right, and so that's why, it's my understanding, that's why he would ask for a Ryan stay now. But the same thing would apply when the court affirms the judgment, because this case would now be over. And so the state rule that would prevent the CCA from considering a successive application would be gone. The other reason is.
Well, let's back up. If we were to find that state habeas counsel was ineffective and that there was a substantial claim that was should have been raised and was not, that's in front of us de novo. That's what the Supreme Court's jurisprudence.
If it's procedurally defaulted, yes.
But Trevino says the excuse for procedural default is ineffective as state habeas counsel.
Correct.
So if we find there was ineffectiveness of state habeas counsel, then we've got the issue that should have been raised by state habeas counsel was not in front of us de novo.
That's correct.
Okay.
Absolutely. Now, the petitioners, as to the second claim, which has to do with the missing evidence, he concedes that that's either procedurally defaulted or not properly before this court. So I'll turn to the first claim. That's the Dr. Regan claim that's been the focus of the opening argument. That claim fails on its merits, even if reviewed de novo. And part of the reason for that is that the state habeas court made findings of fact that foreclosed this theory. And those findings of fact, even though this claim was not fairly presented to the state court, the findings of fact are independently entitled to deference under AEDPA. The petitioner can't overcome those by clear and convincing evidence. So for example, the state court found that trial counsel's theory in mitigation, which has to do with depression, this group of friends, alcoholism, his father, all of that was reasonable. Look at finding of fact 23 and 24 and finding of fact 245. There's also a finding of fact going to the lack of more typical mitigation evidence. That's finding of fact 147 to 48. As to the threat to society, Vegan, of course, as discussed in the first part of the argument, I certainly dispute that Vegan conceded the special issue. The special issue is both broader and narrower than the question that was framed by the prosecution on cross. On this record and based on the state habeas court's finding of facts, there's no way that this experienced defense lawyer was confused about the law in Texas, about whether or not conduct in jail is the only consideration. The state habeas court actually has a finding of fact saying that these are experienced counsel, that their conduct during this trial was reasonable, that they've handled capital murder trials in Texas before, and that they generally know what they're doing.
I had forgotten she had co-counsel.
Your Honor, at trial there were 3 lawyers. Lead counsel was a Mr. Sanchez, and then there were 2 additional lawyers as well.
Oh yeah, he did the examination of Vegan. Okay.
Yes, I believe it was Ms. Ivory.
No Sanchez's name, I thought, but maybe, anyway, go ahead.
So the combination of reviewing the record holistically and looking to the state court's findings of fact amply supports the district court's conclusion that there's no deficiency by defense counsel on this claim based on Dr. Regan. Of course, even if there were, the petitioner would need to show prejudice. And he can't do that because on special issue 1, it's not true on this record that this issue was injected solely through Vegan. The second witness who took the stand for the defense during the punishment phase, Father Paul, was asked about the defendant's assault, conduct in jail, making shanks, and all of those things. That's in volume 23 of the reporter's record. You can look at page 49 through 50 for that one. And there are other references as well. It's clear from the prosecution's cross during the fact witnesses for the defense that the prosecution was going to make an issue of this. And of course, as counsel recognizes, the prosecution could have brought it up in its case in chief. Now it didn't, it's true. They got a gift in that the prosecution didn't bring it up in their opening case. But looking at this record, the only way for the defense to completely avoid opening the door to this evidence would be to put on no mitigation case at all, because the prosecution started getting into it right away.
Insofar as the evidence of Johnson, is that the name of the prisoner, of that assault? Dr. Vegan goes through what he examined, and that's the first place I saw in his testimony where he mentioned looking at prison records. And so he looked at the prison record, disciplinary record, something like that. And then when he gets asked on cross about Johnson, he's got it in front of him, or maybe just his notes about it in front of him. Do we have the disciplinary record in this record, to your knowledge? What concerns me, my interest in that is, it seems to me that all that came out in the cross-examination of this psychologist is he had a fight in prison with another inmate. No shank, no particular brutality, and he started. And you can tell me, or your friend on the other side can say that, but I don't see in the testimony anything particularly extraordinary. It was a fight in prison between these two, and that Mendoza started. And then the counter argument is, in fact, this was the new evidence that this was fabricated, and that's not how it happened. But I guess I'm thinking of it more in terms of prejudice. I just see this in terms of a fight in prison by a fellow in there for murder. I don't know if that would strike the jury as a particularly extraordinary event that would weigh very heavily. Of course, you don't think so. But your friends may think otherwise. But is that true, that it was just, that the only thing I saw in his testimony is that he did mention there was a fight. He acknowledged that Johnson and Mendoza had this fight.
Absolutely, yes. I don't think that this was a key part of their testimony.
There's no knives, no pummeling the guy to the
No,
floor.
I don't think that this was going to be the determining factor on any of these issues. And of course, the new affidavit from Melvin Johnson, as everyone agrees, is not properly before this court under E2. So that evidence, I think, wouldn't have prejudiced him regardless. And none of the other evidence does either. The second question, of course, goes to the general mitigation. And on this general mitigation, petitioner has two basic complaints about Began's testimony. First, that the general strategy of saying that he lacks a moral compass right now is immature, was unreasonable. Of course, the state habeas court found otherwise. And there's no showing here that the absence of that sort of phraseology was going to overcome the really troubling, brutal facts that the jury had already heard. They had already heard that he showed no signs of remorse in the days following this murder. For example, you can see at volume 20 of the reporter's record at 2:02, while Rochelle Tolson's body burned in the woods, he was chatting with his friends on the cell phone. The jury had heard all of that in the guilt stage. And then during both the guilt stage and the punishment stage, it heard all about his upstanding family, his background, that he was intelligent. It heard testimony from his 9th grade algebra teacher that he was intelligent, could keep up with the work. He didn't really try, and he would fly off the handle at nothing. She testified that she was afraid of him. That's just one example. More and more, of course, that's not even to mention the assault on his little sister, the assault that involved choking on a girl in the middle of a party. Dr. Began's testimony was not the reason that the jury answered the questions the way it did. So he can't show prejudice here. So if there are no further questions, I'll yield the rest of my time.
Just one thing I asked you what Began said about the fight. Did Officer Hinton, whatever his name is, talk about it being a particularly brutal fight?
No, he described it as, they started a fist fight and it went on for a couple minutes until some backup arrived.
Thank you.
I'll pick up with Judge Southwick's last question about Dr. Began and the prejudice from his testimony. Setting aside the fact that in our view, the entire rebuttal case, including the 4 witnesses, the door to that was opened by Dr. Began, even on his specific testimony about the prison fight, that we know that's prejudicial because that is what the jury asked about in its deliberations. And the first thing that counsel said, counsel for the prosecution said in their closing argument was, we know he's going to be a danger in prison because he's already gotten a prison fight, and we know he's a danger in general society because Dr. Began told you he is, so you know the answer to special issue number 1. So the prosecution said in closing, and the jury asked about it in deliberations, the very testimony from Dr. Began that we're talking about. I want to address very briefly the notion that the state trial court has already somehow resolved issues against us. They haven't. Any issue resolved in the the state trial court decision on reasonableness, that's a mixed question of fact and law. That is not subject to 2254E. I think that's the statutory provision, so it isn't owed any deference. The state made this argument in its COA opposition brief, but didn't actually make it in its brief on the merits, and I think the reason why is because these are mixed questions of fact and law, and they don't get deference, so they're not really relevant to this court's disposition of the issue.
You're talking about the specific finding that the mitigation case was a reasonable presentation. Is that the finding you're talking about?
In general, I think, I don't know specifically which ones she referenced because I didn't go back on the record, but any of them that are going to be relevant that's about reasonableness is a mixed question of fact and law under Strickland. And we address this specifically in our COA reply, so if you're looking for briefing and citations on that, I would direct the court to the COA reply. On the question of mitigation, counsel said there was no chance that a jury would find mitigation on this record. I strongly disagree, and I think the most powerful reason that not one single juror found mitigation, and again, that's a standard, we needed only one vote in dissent, is that the expert said that the factors in mitigation were absent, traditional factors. He'd been an expert in hundreds of capital cases, and did not, in our view, offer anything for the jury in the alternative. I don't think there's a coherent explanation on this record for what Dr. Vegan was doing. If the court is satisfied with jurisdiction, I'll skip past it, but mention one thing. If the court wants to give life to Martinez in this particular context, the argument we lay out on page 22 of our reply brief gives, I think, the doctrinal roadmap for how to work Martinez in to the second or successive bar, and that's through the pre-abuse of the writ doctrine, which incorporates cause and prejudice. And then I'll talk last, right now, about the Rhines issue. Counsel for the state asked the court basically to cut the failure to investigate claim loose from this case, just affirm, and then have the claim go to Texas state courts where it could be litigated. And as Judge Richman observed, from our perspective, the reason that's highly problematic is then we lose forever our federal forum. The claim would be barred by the statute of limitations. If it were cut out of this case, we might have a second or successive problem. So if the court just affirms and sends us to state court, we're most likely not going to get back here.
Well, you have considerable procedural problems in federal court, too.
So we have an evidentiary problem under Shin, and Rhines is designed specifically to resolve this issue about cutting a claim loose and having a statute of limitations or second or successive bar. That's the reason Rhines exists. The claim's brought in federal court within the statute of limitations. The federal court puts a pause on the federal litigation. You go to state court, and then you come back. So you don't lose your federal forum for your federal claim. Counsel also argued, it was sort of a hydraulic argument, like we lose if we do this, we lose if we do that. We disagree with it, but I just want to make one point very clear about the procedural default. Our argument is that the claim was most likely procedurally defaulted when originally brought by counsel. But after Shin came down, it became clear that this claim could no longer be litigated on the merits in federal court. And that provides us with a good faith basis to argue to the Texas Supreme Court that it should reconsider its precedent prohibiting second or successive applications based on the ineffectiveness of state habeas counsel. The Texas Supreme Court before Shin had already
Just a correction, the Chief Justice of the Supreme Court of Texas is not particularly familiar with what you're talking about, but the Court of Criminal Appeals is the place where your arguments would be made. But O'Melveny probably doesn't appear in the Court of Criminal Appeals.
I would appear in this case for that reason, but the court, I take your point. The point is.
We knew you meant.
Say that again?
We knew you meant.
Yes. So the point is, and I see my time is up, if I may just finish the point. The point is that we want to make that argument to the Texas Supreme Court in this case while the federal litigation is still pending, so we can preserve our federal forum for federal claims under Rhines. We believe that after Shin was decided, we have a very good faith basis for making the argument that they should reconsider Graves, because if the Texas Supreme Court doesn't reconsider Graves, and they had already signaled a willingness to, but if they don't reconsider Graves, then that means that petitioners like Mendoza will never, ever, ever have a federal forum to hear these, will never have any forum, to hear these claims based on ineffectiveness of state habeas counsel. Thank you.
Counsel.
We know that you were pro bono, and we very much appreciate your willingness to take this case. You've done an excellent job for your client. Thank you.
Good lawyers on all sides.
On all sides. The court stands in recess.